did expect that result, and you don't have to take my word for it. You can just look on Twitter, because a few days before the ruling, I made some comments on Twitter and predicted that this would happen, and that this might just be the beginning of some unpleasant legal consequences. That's the term I used. I wasn't at all surprised. I would have been surprised if the judge hadn't made such a ruling. And the reason is because either through a lack of situational awareness, or lack of governance internal controls, or lack of common sense, or or something along those lines, in my view, the Big Ten made a colossal tactical mistake in filing that pleading and saying that in affidavit form, under oath, that there was a vote of 11-3. Why do I say that? Because anybody paying attention knew that 2, arguably 3, of the 14 voting members had publicly stated various versions of "we didn't vote."
And that's, just so everyone's clear, that's Minnesota, that's Michigan State, and the third one I think you're arguably saying is Penn State.
Yes. One of those versions was, quote, "we didn't vote." I think everybody understands what that means.
That's pretty crystal clear. If you're a reasonable juror, it's pretty clear.
Yeah, go back to Jack Nicholson. Yeah, crystal clear. And one of the comments was, "we didn't vote per se." I think that's Big Ten collegiality speak for "we didn't vote." And another comment was, it was more of a deliberative process, a collective action. Well, folks, there's an important legal distinction between a deliberative process and a vote. And I'll use this example. If the jury returns to the courtroom at the end of a trial, and the judge says to the foreman, "Mr. Foreman, has the jury reached a verdict?" All of us who've been in trials know that the foreman responds with yes, and they have voted and they return a verdict. And oftentimes the verdict is verified in open court. In this case, it seems like at least some of the university presidents are saying that if they were the foreperson, they would have said, "Well, no, we didn't vote, but we talked about it for a while and decided the defendant was guilty." And therein lies the big difference between just talking about it and coming to a consensus that apparently one person gets to assess that there is a consensus. That's an entirely different deliberative decision-making process than having a vote. And I can't understand for the life of me why there wasn't, and I know I'm going to say this again, I've said it before, if I sound critical, it's because I am. Because this is off the charts bad. off the charts bad lawyering, off the charts bad decision making, off the charts public relations, off the charts poor governance. But you would think in that organization, that every organization I've been a part of, big or small, there's been somebody in that organization whose job it is to say, "No, that's not a good idea." And looking at that pleading, I looked at it as soon as it was filed. I mean, the minute I saw that in that affidavit, I was just shocked.
So, it's Tom. We had I'm not sure how we got it, but we got a copy of this. The brief that was filed by the Big Ten, and it laid out. We didn't have access to it before, but that the Big Ten's bylaws essentially said, in order to reduce the games or cancel the season, you need 60% of the members of that conference. So just doing basic math, that's 9 members have to affirmatively vote to either reduce or cancel, however you want to phrase it. Dan and I had this interesting kind of legal debate back and forth. I'm not really certain how the Big Ten thought that their response was sufficient when they provided just a sworn affidavit from one person, right, from the chairman, be it Northwestern. That's one vote, and then he's not even saying which way he voted in his affidavit. I'm just, I'm on Twitter. Dan and I are both very active on Twitter. And Tom, you now are yourself. Welcome to Twitter. We should say.
Active,
Tom's
yeah.
on Twitter at Talon Mars, which I think is a testament to his talents. I think that's what that meant. But I think there is a version here, Tom, where there was just a general, and this is just me speculating, but that's what we do as lawyers. We try to ask the right questions and figure out to get there. If Kevin Warren was leading a conversation, and he said, by show of hands, who wants to play the season, right? And 3 people raise their hands, whoever that might be. Just by some reports, that's Nebraska, Iowa, I think it's Ohio State. I apologize. Now, in that version, those 3 people raise their hands, and they go, okay, you guys are the ones that want to play, and then the rest of the room doesn't want to play. That's an 11-3 vote. My reading of the Big Ten bylaws would mean that was not a proper vote, because that's only a vote for 3 people affirmatively doing something. And my reading of the Big Ten bylaws say that you need 9 people to vote to cancel the season. Is that your reading and your understanding as well?
That's my reading as well. And it's a good point that I think has not been really emphasized enough in the public domain, but that's my reading as well.
So Dan and I would touch. Just quick, Dan. I want to give Dan some credit too. In the Dan has been pointing this out. In order to disrupt the rules of a private organization, you need to show some evidence of egregious conduct. And one that Dan has been harping on is evidence that you didn't follow your own procedure. So one would be not following this proper procedure to vote. I know you've been vocal about it on Twitter, but for those that haven't heard, do you think that the Nebraska players here could establish that this own vote wasn't, didn't follow proper protocol? And if they do, what happens then?
Well, I should say that before that lawsuit was filed, when Mike Flood was threatening to file it, I was extremely skeptical, so skeptical that I thought he probably wouldn't actually file it. And I think benefit of seeing what's happened since he's filed it, having studied the lawsuit, not having talked to him, I've never spoken to him. We're not collaborating, but I think that's just an outstanding example of what I'd call courageous advocacy, because that's a high-profile case, and it could bomb, like on day one. But and the merits of the actual legal claims for relief are novel, to say the least. But I've watched how he's handled that case. I listened to the transcript of the hearing, and another surprise, because I don't know the lawyer representing the Big Ten, but I know his reputation. I know a little bit about his experience. Wow, what an incredible example of a lawyer being caught off guard in a state courtroom that he's not familiar with. He was out-lawyered by Mike Flood, in my opinion, from the minute that hearing started until it was over.
Yeah, but Tom, I read his responsive brief. I mean, and quite candidly, he might have been caught off guard by the expedited nature of the hearing without having had a chance to brief the issue. And the issue that I raise, and I kind of agree with, is where does player standing come from if you're trying to assert a contractual relationship with an athletic conference when there's all this case law, Hairston versus Pac-10, which stands as the leading case, which rejects the concept of players having third-party beneficiary rights by virtue of governing documents of an athletic conference. And then turning to the tort claim is predicated on a name, image, and likeness law that hasn't even been implemented yet in Nebraska. So my cynicism as an experienced lawyer, not nearly the same courtroom experience you have, is that 2 words immediately come to mind: home cooking. So I'm not surprised by the result, but is this the end of the battle, given the standing obstacles that I think still stand in the way?
Well, I was familiar with the case law you cited, which is why I was sort of doing that kind of thing before this lawsuit was filed. And then when I read the complaint, I mean, it was really well done, but as you guys know, creative, novel, there are other ways you could describe it, but be a bit of an uphill battle to take that case to the Nebraska Supreme Court, assuming you get that far and have it sustained. But a lot of things happen in courts before you get to that point. And that's when I shifted and said, well, this guy's going to get limited discovery for sure.
Well, I don't think that there's an immediate right to an appeal here because it's an interlocutory discovery ruling, but could there be some kind of intermediate extraordinary writ relief or some other judicial intervention between now and the response deadline? Are you hearing anything about a possible appeal, writ of mandamus, or even removal to federal court?
No, my knowledge of that lawsuit, guys, is no different than yours. I was able to get my hands on a copy of the complaint, and I read commentary. But let me say this. God forbid this was going on in the SEC, but if it was, there were 75 counties in Arkansas. I'm certain that I could find a state judge in Arkansas in one of those 75 counties that would have enjoined the SEC from canceling fall football, regardless of what laws are on the books.
Okay.
Now, I don't know how things work in Nebraska, but having practiced law since 1985, mainly in Arkansas, I can tell you that there are ways to get that done, and within the bounds of ethics too, because judges have different opinions. And one of the things everybody has to keep in mind is that a lawyer doesn't violate any ethical rules when he or she asserts a claim for which there's no legal precedent, as long as that lawyer is willing to acknowledge to the court that he's asking the court to extend precedent that exists in that state. And of course, in this case, the argument might be this case is different. Every case is different from every other case. But
All right.
I agree with your assessment from if we were in a law school class, that would be my assessment. That's what I'd be saying to the class, and that's what I'd hope the students would be saying back to me. In the real world, it's not quite that way.
Well,